when the Election Commission sought date for appointment of elections, confusion that in case the assembly is dissolved upon the advice of the Prime Minister, who shall appoint the date, because governor, if it is not instrumental in the dissolution, like in the Punjab, the assembly was dissolved on the advice of Chief Minister of Punjab. The relevant article says that upon the advice, the governor shall dissolve the assembly, and if he fails or if he considers not to dissolve or if he is inactive, then after the lapse of 48 hours, assembly would be deemed to be dissolved. So this is the point of controversy from where this entire the litigation Pandora was open. The Governor Punjab did not acted upon the device, and the assembly was dissolved as per the flux of time, like on the passage of 48 hours. So the first round of litigation was regarding the fixing of date, that who to fix the date. The matter was brought before Lahore High Court. Lahore High Court, after hearing the parties, directed the Election Commission to appoint a date after consultation. And the governor filed an appeal in the Lahore High Court, which was pending. In KP, the governor was in process of consultation, and a writ petition was also pending in KP. When a two-member bench of Supreme Court of Pakistan, if you may recall, while hearing a petition regarding the removal or the transfer of a police officer, they took it so seriously and they considered that elections shall be held in a stipulated period, which is 90 days, and the time was passing through. So that the bench headed by Justice Ijazul Hasan, flanked by Justice Mazahir Naqvi, referred the matter to the Chief Justice of Pakistan to examine it and, if appropriate, take suo motu notice by constituting a bench. Pursuant thereto, a 9-member bench was constituted by the Chief Justice of Pakistan, which assumed hearing. In the initial hearings, 2 honorable members passed judicial orders. They recorded their separate opinions, and they said that since the matters are pending before the high courts, and since 184.3, constitutional provision 184.3, which vests jurisdiction in the Supreme Court to take suo motu notices or exercise its own constitutional jurisdiction, is a concurrent jurisdiction with the high courts. So the case was not found to be fit for exercise of that jurisdiction, and it was found appropriate, if the High Court pleased with the matter already, may continue with the proceedings. They recorded their separate opinions. In the meanwhile, the bench was reconstituted by the Honorable Chief Justice, because meanwhile an application was filed by political parties requesting that 2 honorable judges had already expressed their opinions, and there were certain other backgrounds regarding their conduct as judges. So they may recuse themselves from the proceedings, which is not something which is happening first time, I would say. We have experienced so many occasions where objections were raised or request was made to the honorable judges that they have some conflict of interest or they have expressed opinion already in that case. So they may recuse. 2 honorable judges who initially referred the matter to the Chief Justice, they voluntarily recused themselves. Meanwhile, 2 honorable judges had already expressed their opinions through separate orders. The matter was then placed before a bench of 5 honorable judges of Supreme Court, and at the conclusion of hearing, the one view is that the petitions were accepted, like the case was disposed of with majority by 3 against 2, directing the Election Commission to fix date in Punjab in consultation with President of Pakistan and date in KP in consultation with the Governor of Khyber Pakhtunkhwa. However, in the same order or judgment, the 2 honorable judges concurred with their 2 learned colleagues who had already dismissed those petitions. So that is the point from where this legal controversy actually started. The government was on record, I being the law minister and the Attorney General, the then Attorney General for Pakistan, we expressed our view soon after the announcement of decision that those proceedings were disposed of or dismissed by a majority of 4 against 3, because 2 honorable judges said that these petitions are not maintainable, lack jurisdiction, and the matters be placed before high courts for appropriate orders. Those two opinions were concurred to, followed by two judges sitting in the 5-member bench, and they put footnote as well to clarify the situation that under the dispensation, under the scheme of law, under the court practice, such orders can be passed. So it was a decision taken by the government and many segments of the lawyer community and the society as a decision dismissing the petitions and referring the matter back to high courts, which also the proprietary demand that if the independent high courts were seized with the matters, they should have proceeded with the same. However, the decision given by 3 honorable judges, the Chief Justice and 2 other members, that decision was presented as order of the court. So once again the controversy erupted, the which decision to be acceded to. The government took the stance, the parliament as well, that the decision is of the 4 judges, which is majority decision. When matter was re-agitated before the Supreme Court of Pakistan through petition filed by Pakistan Tehreek-e-Insaf, their speakers of the outgoing assemblies, at the outset this objection was taken by the principal law officer, the Attorney General for Pakistan, reminding the Honorable Court that a larger bench may kindly be constituted to resolve this controversy first, because it is a jurisdictional important legal question which is to be answered by a larger bench. Larger bench means they requested for full court, and in past we have at many occasions saw that the entire Supreme Court sat together in a full court bench and they decided the matters, especially when the matter is of some national importance. That request was not acceded to. The political parties who were previously part of the proceedings, which include Pakistan People's Party, Pakistan Muslim League N and Jamiat Ulama-e-Islam, they also filed applications that they be implemented as party because they did have the parliamentary presence in the dissolved provincial assemblies. And if it is a question of public importance, if it is a question of enforcement of fundamental rights, it is the fundamental right of the party, political party, to take part in the process of election. And they also represent a large number of their members. Those constitute public at large. Surprisingly, their applications were not entertained. They also raised certain objections, requested for constitution of a full court, barring those 2 honorable judges who had already voluntarily opted to recuse. But despite all that, the 5-member bench resumed hearing. In the meanwhile, another order was passed by a 3-member bench of Supreme Court of Pakistan, headed by the senior pune judge of the Supreme Court, Justice Qazi Faizi Sa, who handed down a verdict that since the manner in which the jurisdiction under 184(3) of the Constitution, which is the suo moto or original jurisdiction of the Supreme Court, that manner has been under discussion in full court meetings and by the different segments of society, including the political factions and the law societies or the bar councils, bar associations. The judgment also directed the office of the Supreme Court that matters pending before the Supreme Court arising out of 184(3) proceedings may also not be listed for hearing or may be halted in the meanwhile. And a full court meeting was desired by the bench, that a full court meeting of honorable judges be convened to resolve this issue. Such meeting was also convened back in 2019, and these issues were discussed for framing of rules, but unfortunately thereafter no progress was made. That judicial order was also overturned by an executive circular issued by the Registrar Office, upon which a show cause notice was also issued to the Registrar of the Supreme Court that why should he not be removed, and the displeasure was shown by the head of the bench. Confronted with the situation, one after another, 2 honorable judges, part of 5-member bench who was seized with the matter, hearing the case, they decided to leave the bench. That they decided in their own wisdom that they should not sit on the bench unless until the orders of the judicial orders of three-member bench are not complied with, they actually, by dissociating themselves with the bench, they acknowledged, and not only acknowledged, but they followed the diktat laid down by, or the orders passed by a three-member bench headed by the senior punier judge, that all proceedings arising out of 184(3) may kindly be halted in the meanwhile. At that juncture as well, the request was repeated by Attorney General for Pakistan that there are two serious constitutional legal issues involved in the case. One, whether it is a judgment by majority of 4 against 3, or the previous judgment was by a majority of 3 against 2. This matter, the very important constitutional question, needs to be addressed by the court, and for that matter, the full court may kindly be constituted, and if not an alternative, the remaining judges, which are 6 in number of the Supreme Court, who are not part of that 9-member bench, they may be, the bench may be constituted, and the matter may be referred to them to settle this controversy. This request was also not acknowledged and turned down by the 3-member bench. The other, of course, was the presence of the judgment handed down by senior punier judge, which directed office that cases involving question of under 184(3) may not be listed for hearing, and question was raised that in order to overturn that judgment, a judicial process has to be evolved, that a larger bench be constituted or matter be referred back to that bench for final adjudication, and it was not a matter to be dealt with by a executive circular. The honorable bench, the 3-member bench headed by Chief Justice, overruled all these demands or objections or requests, and finally passed an order whereby they themselves issued a schedule fixing 14th of May as the date for polling, and the different stages of election were also elaborated, and directed federal government to provide funds and security, which were actually earlier refused on multiple grounds, and Election Commission was satisfied with those grounds after examining the same, that the conditions were not conducive for conduct of election for multiple reasons, primarily the security, ongoing security threats and situation, and the incidents being taking place in KP and Punjab different occasions. Moreover, in the current financial budget, the allocation of funds was not made, and considering the economic conditions of the country, time and again elections and spending huge amounts were whether advisable or not advisable. This was also Election Commission. So they, in their own wisdom, they posted the date of election for 8th of October. The Honorable Supreme Court finally passed an order directing that no, this is no justification, the election be held on such and such dates. The government of Pakistan also took up this matter. The cabinet sought views of the legal experts during the meeting, the lawyers who were representing the political parties, and the principal law officer, the Attorney General for Pakistan. And the cabinet also resolved that it is a serious constitutional question regarding the original judgment which was handed down by 4 honorable judges rejecting the petitions. And minority view should not be implemented or imposed upon the authorities. And it would be in fitness of things that if at even that stage the court considers for referring the matter to a full court, barring those 2 judges who have already recused themselves. The matter was also discussed at length at the floor of the Parliament, which is the proper forum to discuss important national questions, including any legal issues being faced by the nation or by the government, or having strong nexus with the national affairs. And the National Assembly also passed a resolution in the meanwhile requesting the Supreme Court of Pakistan to consider under the propriety principle, the procedures, as well as the good practices, and to ensure transparency and independence, that the matter may be taken up in the full court. That resolution has also not been given any weightage by the court anyway. So faced with the situation, the matter is now under discussion in the parliament. To great extent, it's being discussed here and there. That's why I find it appropriate to come to you, answer your questions, if any. I just opened up the topic with basic history and details. So any question?
Azam sir, this is Rasi from CNN. I just want to know that, as we know, we have gone through the proceedings and your wonderful presentation today, briefing today. When we see the Constitution, there is no constitutional solution. Within the framework of Constitution, there is no solution. Then there is only one way left. You can't invoke emergency according to Article 232 because the President is there. One of your colleagues has attempted to give a solution which is yet a controversial solution, that government is thinking to file a reference against the 3 judges. So how serious this move is? Rana Sanaullah has said in one of his interviews that they are thinking to file it.
It may be under consideration, but there is no decision as yet. And I think that it may or it may not be an option for that. It has to be thoroughly examined and pondered upon before making any such decision. And that decision, of course, is to be made by the federal government, which is the federal cabinet. But so far, there is no such serious move, with all fairness, I would say. However, as you suggested, there is no solution. No, there is a solution in the Constitution. Article 254 of the Constitution provides in unequivocal terms that if Constitution provides an act or a thing to be done within a stipulated period, and if that exercise or a thing has not been done in that specified period, it would not be unconstitutional only for the reason that the same was not carried out in that stipulated period. Now, coming back to the instant issue that the elections are to be held in 90 days or not, the 90 days upper capping started, the period starts from 12th of January, which is actually the 90 days are being exhausted on 12th of April, which is around the corner. And in any way, case the election have already been ordered, whether that order is purely constitutional or legal, or whether it is executable or not, because of the controversy which is yet to be determined, whether it is 4-3 decision or it is a 5-3 or 3-member decision. So in the presence of 254 in previous events, at previous occasions, in 1988, the assemblies were dissolved the last week of May. I think it was 29th May, if I'm not wrong, by then President Ziaul Haq under 58(2)(b. 1988, when the Junejo government was actually dissolved by the President exercising its powers under 58(2)(b) of the Constitution. Now, the elections were to be held within a period of 90 days. So, the May, June, July, August. But the polls were conducted in November 16th, November, the exact date I recall was either 15th or 16th of November. So, at that time, a presidential reference was also sent to Supreme Court of Pakistan, because there were some issues regarding the expenditures, because in the meanwhile no budget could have been passed by the Assembly. And the Supreme Court of Pakistan, invoking Article 254, allowed the expenditure as well as also indemnified the period which was consumed in conducting the elections, almost 5.5 months. Even in recent past, in year 2007, the assemblies, the National Assembly and provincial assemblies were to retire somewhere in the middle of November as well. So the Khyber Pakhtunkhwa Assembly, which was NWFP Assembly at that time, was dissolved in first week of October. And the rest of the assemblies, they completed their tenure in middle of November. So elections were to be held somewhere on or before 15th of January. In the meanwhile, Mohtarama Benazir Bhutto Shaheed, she was assassinated, and the law and order situation in the country was not so well and stable to go for election. So Election Commission postponed the election without intervention of any court, exercising its powers vested in it under Article 218, read with Section 8 and Section 58, 759 of the Act of today. उस वक्त उसमें 103 of the रोपा था. So elections were finally, I believe, held at the end of the February. And now you recall the KP Assembly was dissolved in first week of October. So their caretaker setup remained there for a period of 5 or more months. So it's not the first time, and that's why the Constitution provides a provision which covers these kind of situations and remedy the delays. Moreover, it is the Election Commission, to my understanding, which is the body under the Constitution to ensure that elections shall be conducted in a manner which is transparent, which is fair, which is just, which is independent, and where the corrupt practices are guarded off. Pakistan, as I earlier said, has a unique scheme under Article 2 to 4 of the Constitution, which provides the appointment of caretakers through a consultative process, a very transparent process, that leader of house, leader of opposition shall decide the name of the caretaker, head of the government in the meanwhile. If they don't agree, the committee consisting of 4 members from opposition, 4 members from Treasury benches, they will resolve the issue in 2 days, and if they fail, then the matter would be referred to Election Commission. This exercise was carried out in Punjab. There was no consensus. Matter ended up with the Election Commission. With 5-0 unanimous decision, the caretaker chief minister was appointed. Likewise, unlike Punjab, in KB province, the outgoing leader of opposition and leader of house, they concurred on the name of Mr. Azam Khan, who is, and then the caretaker governments were lodged. My understanding is that if elections are conducted in piecemeal, that the elections in Punjab are conducted right now, and election in KP are conducted in somewhere in July or August, which is also, if we go by the judgment, it is also the violation.